Today, the Supreme Court struck down a key provision of the Voting Rights Act, a landmark civil rights law from 1965 designed to protect minority voters. In a 5-4 ruling, the court threw out Section 4, which required mostly southern states to get approval from the Justice Department before changing their voting laws. The justice said it's now up to Congress to update the law. President Obama says he's, quote, deeply disappointed, and here's Attorney General Eric Holder's response.
Now, like many others across the country, I am deeply disappointed with the court's decision in this matter. This decision represents a serious setback for voting rights and has the potential to negatively affect millions of Americans across the country.
If you wouldn't mind me just giving a comment here in the front end, because my dad was very much involved in seeing this bill get through. I think I understand why southern states collectively should not have to be under this law, because a lot of them do things right now. But there are counties in these states where they still practice discrimination, and they have to be accountable somewhere. If they throw Section 4 out of this thing, it essentially guts the whole civil rights bill. And it's got to be, Congress has got to come forward and codify this thing in a way that says these particular counties, until they pass a certain stress level, have got to report in before they make any changes.
And Congress might do that. And this is an opportunity for, if President Obama is as deeply disappointed as he described today, then they just need to put their shoulder behind it and try to get it done. And I think there might be some willingness in Congress to address that. I can understand being disappointed in Supreme Court decisions. If you think of Obamacare, God, I cried.
Okay, well, let's not get back to that again.
No, I'm just saying that, Bob, that the Supreme Court, what they're telling Congress is, you need to do a better job, and that's what the Supreme Court's rule is. It's not that they want anybody to be denied voting rights.
Yeah, whatever there's a 5-4 decision, that usually means they want somebody else to handle it. Go ahead.
Can I read this in a positive light? That the states that were involved, yeah. Alabama, Georgia, Mississippi, Louisiana, et cetera, there's 10 of them, are doing things have gotten so much better in those states that they don't need.
That's what I said. That's what I said. Go ahead.
But I don't think that anyone is arguing that in 1965 it was unnecessary, because I do believe, I agree with you, Bob, it was a remedy to a really serious wrong. However, the portions that prohibit discrimination are still in the Voting Rights Act. You say that they've gutted it. I don't believe that they have.
Well, okay.
And you know, these states should be able to act on their own. And the data, this is according to Chief Justice Thomas, he says it's no longer valid anymore. He says they've changed. And so what you see with this decision and affirmative action is slowly but surely the court is weaning us off of civil rights laws very carefully, very slowly, but they're allowing discrimination provisions to stand up in the Voting Rights Act.
Okay, well, Greg, what do you think about this? Do you think that there still is some need to have oversight over some of these voting areas?
I don't really know.
Okay, thanks.
No, I don't, and I think most of America doesn't know either. But anything that Holder calls a setback has to be good, because this is a guy who he really didn't think the new Black Panthers in Philadelphia at the voting polls was a serious setback, suing specific states over certain things. That wasn't a serious setback. So when Holder's disappointed, I walk a little happier.
Well, but I agree with you on
Can we do this? And Greg makes a very good point. Maybe most of America doesn't understand exactly what Section 4 is. Section 4 was a formula used to determine which states had to get federal approval to change voting procedures. Those states had a history of racial discrimination. My point is, if those states don't have that history anymore, why are they bound by Section 4? They don't need to be bound by Section 4.
Because there are parts of those states that still need to be bound by Section 4. There are counties in Florida, there are counties in Mississippi, Louisiana, where the sheriff runs the voting day. I've been down there trying to deal with them in campaigns I've done, and they absolutely discriminate against
But that's still illegal. We didn't change any legality of that.
I don't want a county sheriff out of certain counties in Mississippi to have the right
illegal. And I did misspeak before. Clarence Thomas actually said he would strike down clauses 4 and clauses 5. It was Roberts who wrote the opinion on this that said, look, the data's outdated. Show me some new data. But for now, that pre-clearance is not necessary for these states.
But Congress is going to have to act on this, because if they don't act on it, you're going to find there'll be disenfranchised voters in certain southern counties, and it's just wrong.
So you think Mississippi and states like that will just go right back?
No, I don't. I believe Mississippi has done a very good job. I don't believe it was anything like it was in '65, but I'm saying there are certain areas of it which haven't changed much since '65, and they still prohibit blacks, or they make it very difficult for blacks to vote.
Bob, the data in '65 is unbelievable. You have 69% of whites registered compared with 6% of blacks.
Exactly.
That is not happening today.
No, it's not, except in certain counties. Again, this is why you got to codify it. You've got to say what percentage of your population is registered to vote, and you have to pass a stress test basically to do it. But anyway.